Hi, my name is Amanda Rocha. I am an estate planning and probate attorney in California, and today I'm going to talk about whether or not you are an heir or a beneficiary to someone else's estate and how to know if you are. Before I get into that, I want to give you my contact information. You can find me on my website at www.amandarocalaw.com. You may comment down below if this platform allows you to do that, or follow along on my social media at Amanda Rocha Law. I do get this question quite often, and that is, I think that I'm a beneficiary to so-and-so's trust. How can I find out? Or I think I'm an heir. How do I know if I'm going to be inheriting based on this person's will or whether or not this person had a will or not? How do I know if I'm their heir? There are a couple of ways of going through this. So for the sake of explaining, I'm going to break this out into whether you're a beneficiary under a trust or whether you are an heir through someone's will or whether someone did not have a will if you're their heir. So first, let's talk about how to find out if you're a beneficiary to someone's trust. First and foremost, if that person who created the trust is alive, then you don't have an interest generally in what their revocable trust says. There are always exceptions to this rule. Sometimes people will give gifts during their lifetime, but for the sake of figuring out whether or not you're a beneficiary to someone's trust, you can ask them if they're alive. Now, once they've passed away, if you are not the trustee, how do you know if you're a beneficiary? A trustee has duties given to them by the legislature, and one of those duties is to notify in writing every beneficiary of the trust, notify them when that person has passed away, and then to let them know what they receive. As a beneficiary of a trust, you have a legal right to obtain a copy of the documents that talk about what your gift is. And if you are unsure who a trustee to someone's trust is, there are different ways you can go about looking for that information. I recently posted a podcast and a video about that, so you might want to scroll just a couple of videos ago and see how to find out if someone had a trust and where to find it. The next question is, how do you know if you're an heir to someone's will, to their estate, if they had a will or if they didn't have a will? This one is going to be a little more tricky without a will. So with a will has to be lodged with a probate court in the county that the person resided in after they've passed away. That information is public. You can go onto the county's website. If they have cases listed online, you can download that document. It might cost a couple of dollars. If they don't have an online system, which I think most in California do at this point, you can go into the courthouse and pay for a copy to be made. It'll be a few dollars. That will then will tell you exactly what they put in there. If it's a person who passed away without a will, that's called intestate succession. And that is basically going to go through probate, and that person's property will be passed along in the way that the statutes have set it up to go. And depending on who you are, it will depend on whether you may be an heir. So first of all, if this person was married when they passed away, their spouse is going to definitely be an heir if they did not have a will or a trust saying otherwise or other arrangements. If this person had children, if you're one of that person's children and they passed away, you may be an heir if that person wasn't married, or if you were their child from a different spouse than their current spouse, if that makes sense. So if they passed away married and that their spouse is not your other parent, you may be an heir. There are tons and tons of resources about how to figure out what intestate succession order is in California, but basically it's spouse and children, and if those people don't exist, they will look to that person's parents. If that person's parents have predeceased them, then they will look at that person's parents' other children, so they'd be that person's siblings generally, and go down that line. If those lines don't exist, they'll go to grandparent level and go down those lines. And after grandparent level in California, if there's nobody who exists, basically the estate is going to go to the state. Not all states go to the grandparent level. California does. So we're fortunate that somebody who could be a great niece of someone may be an heir to their estate. So first I would check to see if there's a will lodged with probate. If there's not, check out the intestate succession rules in California. You could Google that. I have blogs about it on my website if you want to just type in the search bar intestate or what happens when you die without a will. That'll give you some more information about that. And if you still have questions, you feel free to reach out to me. I will help you figure this out. I'm at www.amandarochala.com. You can comment down below, or if you'd like to follow along on my social media and comment that way, it's at Amanda Rocha Law. Thank you.